Well, the good news is that by having a trust, you get to put in provisions where that money will suddenly become no longer available, quote unquote, for purposes of how these institutions measure their eligibility. So that's just one example. Think of the power of that, though. You may say, well, my kids are healthy. Well, my kids are healthy right now, too. But I don't know that they're going to be healthy 20, 30 years from now. And not to mention my grandkids,
right,
which I don't have yet. But anyway.
It's coming.
Yes, I'm confident
Someday.
of that.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. We're picking up this week with part 2 of what we discussed in our last show.
Yeah.
And the focus in the last show was to answer the question, why plan? And we presented one alternative that many people choose, which is to sort of, by a piecemeal approach, have individual assets transmitted or transferred or conveyed to their loved ones. We didn't talk much about a will, but we can talk about that too as an alternative to what we would consider a good plan. Many would say a will, well, that's a plan, and I agree with that. I agree that a will is better than
nothing.
It's better than nothing, and it's better than simply non-probate transfers. And when I use the word non-probate transfers, that's a phrase for you to know, because that's the way that the law in Missouri, and quite frankly the law in all states, because this is a uniform legislation that was adopted by, I think, almost all 50 states that deal with non-probate transfers. And what falls under that heading is all those ways in which you can convey stuff at your death to other people. So it includes the TOD, transfer on death, on your securities accounts. It includes a POD, payable on death, which applies generally to bank accounts. It also includes beneficiary clauses that you would find at your recorder of deeds. It's a way you can transfer real estate at your death. There are also beneficiary clauses, of course.
For like your home.
Your home too. You can do it with your home. You can do it with your retirement accounts, IRAs, 401ks. They will have a beneficiary designation. Similarly, life insurance, beneficiary designation. Whenever we talk about that as being inadequate or a poor way to plan, we're not saying that there's not a place for using those designations, but you use those designations to place those assets under a central level of control. For example, a trust.
Right.
And a trust is really, the standard tool by which you create an overarching plan that is intended to benefit the people you care about for a long period of time, multiple generations. Right. The laws changed about how long can a trust be in effect, and for a long time there was this thing called the rule against perpetuities, where you bumped up against it if you tried to go too far in the future of helping the people you care about.
What's that called?
And their descendants. It's called the rule against perpetuities.
I've not heard that.
Oh, it lurks around out there. I can tell you, it gets a ton of attention in law school, and when it comes up, in practice, it gets a lot of attention.
Okay.
Attention disproportionate, quite frankly, to its importance.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
Especially now that we have new laws where you can have what's called a dynasty trust. You can have a trust that's in effect for multiple generations. And let me say again, as I've said to you all many times, this is not just for rich people. Life's Third Act is not a show that's intended just for rich people.
No.
We hope that some of you out there are. Good for you. But that it's not a show that's designed just for people who have a lot of money. But for those of you who think that trusts are for people who have millions and millions of dollars, it's not true.
And I admit, at one time, I thought that.
Yeah.
I did think that.
You know, we grow up in a culture where when you hear the word trust used, it's probably in a movie.
Trust fund baby.
Yeah. It's used in a derogatory way.
Yeah.
Or it's been characterized in a movie as something that applied to the rich and famous, maybe in the news when you hear about it. So there's this myth that this is something that if you don't have a lot of money, then you should just have a quote-unquote simple will.
Yes.
And I agree that a will, as we've said, is better than nothing. So, you know, if you're only willing to do a will, so be it. And incidentally, a well-done will have what's called a testamentary trust. A testamentary trust just means that a trust comes into existence, but it comes into existence in the will. So that would be fine if it wasn't for the fact that now everything has to run through probate, where you have delay, you have people who are reaching their hands into the probate estate legally, hopefully just legally, but legally is bad enough.
Right.
Meaning if you look at the compensation that's paid to a PR, which is the estate representative, the personal representative, I mean, this is based upon the amount of money that's involved. It could be tens of thousands, hundreds of thousands. I mean, it adds up. And if you read the statute, you can tell lawyers wrote the statute that states the compensation that a personal representative, which is the executor, is supposed to get after you pass. Because if you read the statute, it says at a minimum they're to get the schedule of percentages based on the value of the estate. At a minimum. Now, that doesn't sound like something that you know the common individual, the person off the street wrote. That's something that lawyers, I suspect, had a hand in, and it's a very generous provision. So the bottom line is probate is not something that you want to ask for. It's bad enough that you're going to get it if you've done a will, but it's not something you should sign up and volunteer for. And people who do wills sign up and volunteer, consciously volunteer for probate. Because if you have a will, you are assured probate. Matter of fact, you're promised it because it's supposed to protect your estate. It's supposed to assure that your stuff goes to the right people after everybody who has a legitimate claim has had a chance to take out their portion. So whatever's left is what's going to be available for those you care about.
And, you know, something I want to point out with a will, isn't it true that that will has to be filed within 1 year or the 1 year anniversary of that person's death?
Yeah.
And if it's not, then it's null and void. Am I correct?
Yeah, you have a 1 year period of time for that to be submitted to probate for the will, whoever has it.
And if you don't, then
what happens is it's what's called intestate succession. So what that means is that the state decides through its statute who is to receive your stuff. Contrast that with the fact that, let's assume that you know that you should have a trust. And that would be a great thing, meaning if you already know that a trust is a good thing and you were just thinking, but I'm going to have the trust created after probate or through probate. In other words, I'm going to provide for a trust in my will. Boy, that is a terribly expensive and painful way to end up with the trust. But it's better than not having a trust. But guess what? Thankfully, there's an alternative. You can create a trust while you're alive. And none of that will go through probate. I mean, it immediately, after you pass, you're a beneficiary when you create the trust. After you pass, then immediately the next tier, presumably your children, it could be anybody, but whoever you name, the next tier of beneficiaries, they step into the position of receiving benefits according to the trustee's decisions that you name. And you set the rules. You define what's paid out and when it's paid out. You can give the trustee what's called broad discretion, where they get to pay out what they think is right based on the values that you've communicated. But alternatively, you can have very specific provisions. Only income can be paid out to my children. and then the balance, being the principal of those assets, will go to, for example, to my grandchildren.
And I think that's the beauty of a trust, because you can have it tailored any way you want to meet your wishes. You know, and I do like that.
And I like the way that we characterized it last week, and I want you to think about this whole discussion, as a sort of yield question. Yield. And the yield, unlike when we talk about financial assets and CPAs and financial analysts, those sorts talk a whole lot about yield, and it means trying to get the most return on your money. And it's an obsession on Wall Street and MIT and other places. But for our discussion, there's a counterpart to that. We need to think about yield. But yield means for you and for us, how do we squeeze out the most benefit for the people we care about of every dollar that is in our estate when we leave this world? How do we maximize that yield? And that's a broader subject than something as simple, I would even argue as mundane, as the rate of return. Rate of return is important, and you can certainly better control that through a trust than you can through any of the alternatives, in my opinion. But I'm arguing there's something more important to think about here that includes that, but includes so much more. And that's how you maximize this good for the people you care about, which will include people you've not met yet, such as some grandchildren you may not have met yet, maybe their children, depending on perhaps the size of your estate. But I don't want you to think that you have to have many millions of dollars in order to protect 2 generations or to provide a substantial benefit to 2 generations. So trusts allow you to do that. You get to set those rules. And another thing that is so powerful with trusts is you can let me back up and say other ways that you increase the yield would include putting a provision in a trust that would allow one of your loved ones, whether it's a child, a grandchild, if they have some sort of disability, to receive the benefits that they would otherwise be entitled to without exhausting their personal funds, the money that you have given them. You've placed it in their account, and guess what? Now they're disqualified from getting a lot of the benefits that they would otherwise qualify for. Scholarships for college, income benefits, benefits related to housing and health care. All those things, state and federal government, not to mention even private agencies, have rules, and those rules are governed based upon how much money is available. And unless you have in place a trust that's properly worded, then any assets that they have are going to go onto those financial applications, and they'll be disqualified. They'll almost certainly be disqualified from federal and state benefits. Well, the good news is that by having a trust, you get to put in provisions where that money will suddenly become no longer available, quote unquote, for purposes of how these institutions measure their eligibility. So that's just one example. Think of the power of that, though. You may say, well, my kids are healthy. Well, my kids are healthy right now, too. But I don't know that they're going to be healthy 20, 30 years from now. And not to mention my grandkids,
right,
which I don't have yet. But anyway.
It's coming.
Yes, I'm confident
someday
of that. So you can provide a benefit beyond simply the amount of money that you're sticking in their account. What about protecting them from divorce? You can. That's very easy to do with a trust. And I routinely suggest that our clients consider having a provision that would not pay out all the money at once, but would still make it generously available for a child or a grandchild.
So are you saying distribute over time?
Yeah, I do. I'm not a fan of a provision that dumps all the money in their lap at one time. And again, I'm not assuming we're talking about $1 million or $10 million here. I'm assuming even $50,000, maybe even $100,000. It depends. It very much depends.
Can you put something though in there, saying if they get divorced from the spouse is not entitled?
Well, the way you do it is you let them take the money out as it's needed, and so you it's paid out in dribs and drabs, but it's paid out in a way that they get the benefit. The whole idea is not to prevent them from getting the benefit. You want your loved one to get the benefit. But here's what happens. I can tell you this as a former divorce lawyer. What happens is any money that's given as a gift or an inheritance in 90+% of the cases goes directly into a joint account for a married beneficiary. I can just tell you that's what happens. That's the way the world works. Many of you have seen it happen. Some of you have experienced it. You've gotten an inheritance and it didn't occur to you to do anything else. It never occurred to you to carefully segregate those monies and to assure that they were never commingled with the money that you earned, which incidentally what you earned is a marital asset, so you have to be sure not to deposit that in the same account. So you have to be very meticulous to be able to keep that money segregated sufficiently so that it continues to be the separate asset that it was when you got it. Now, I can count almost on one hand the number of clients I've seen at Cordell and Cordell over the years. Not quite one hand, but the point is a small percentage have been so meticulous when they got that money that they honored those rules. And what happens is people function, a married couple, even if it's a rocky marriage, their money goes into a pot, a single pot, and it gets commingled. And even if they have separate accounts, they put what they earn in their separate accounts, which is a marital asset. What they earn is a marital asset. Your paycheck when you're married is a marital asset. So if you put a paycheck in with an inheritance, $100,000, you put $5,000 in there, a paycheck, and you put it in there for a period of a year or two or three or four. You've been earning interest. Some of the interest was related to your inheritance. Some of the interest was related to the $5,000, which came in a series of payments. And is it possible to, with precision, extricate the amount of money that constituted your inheritance from that pot? I can tell you that most judges have just said no. It's hopelessly commingled. You may say, well, no, wait, I put $50,000 in there. Why can't I pull out $50,000? That isn't the way it works because you had interest on interest and money. Some money was pulled out. The money that was pulled out and used, was that money the 50 or was it the portion that came from your paycheck? So it's a very, you put it in the hands of opposing counsel for the other spouse, and I can tell you that money is likely to be considered hopelessly commingled. Marital. Yeah. So this is just another way in which you increase yield. We're talking about increasing the ability of every dollar you have to do much more good than you might have thought. So yield is important. And why would you choose to do things in which you minimize the good rather than maximize the good? And a trust allows you to maximize the good. What about debts? What about the debts of your children, of their children? Did you know that with proper wording, it's called a spendthrift clause, it doesn't mean your child's a spendthrift. That's simply a phrase that came along, a legal term that's been used for a century now. And all it means is it's a provision that says that a creditor cannot access money that's held in trust. As long as you have a provision in the trust that allows the trustee to withhold paying it out. Not because they want to withhold your child's money. They know that if they give it to your child, then immediately it's going to get taken away by this creditor. So your child agrees, don't give me the money because I'm going to lose it immediately. I'm going to have it taken away by a judgment or a garnishment that may already exist on the bank account where it would go in.
Right.
So the moment that it's paid out, it's gone to the creditor through a garnishment, for example. Alternatively, it'd be a lawsuit with a pending judgment. So you can easily protect that money from any risk of a creditor. Even if your kids are very responsible, they may have that wonderful propensity to be an entrepreneur. And guess what? The average entrepreneur I read once goes bankrupt twice. Now, I know that can't, that's not been my experience of the people I know going to business, but it's been my experience that they go broke.
Sure.
That they have a couple of businesses that fail. And then eventually those who become successful, usually it's not their first business. It's a second or third. And you can protect your child from the consequences of that. I mean, you have creditors who are still out there. Yeah, you want your children to pay their debts, but you'd rather that those debts not be paid with the inheritance that you're providing them.
So I want to kind of get an idea of what this looks like. So say you are leaving your child $100,000, and you obviously, this child has debts, outstanding debts, maybe perhaps a lawsuit. So you don't want to give this child $100,000 all at once, okay? Mm-hmm. So say the debts are for $40,000. Okay, so you're just wanting to give them like a certain amount each time, so those creditors can't come in. So, I mean, give me like a number that would protect them.
Well, here's the way, and that's a good question to raise, because some people, I understand it's not clear how these mechanics work. How do you protect them and still give them the money they need to live on? Normally, if you have assets that are held by a third party, you're allowed to get a lien or garnishment, which is many people don't realize that order is issued to a third party that is holding funds that belong to this child in this example. So that third party could be the trustee. It could be a bank. It could be an employer. So how many of you know that you've heard of garnishments being on bank accounts, and you've heard of employers getting a notice that they have to pay?
Sure.
Now there are laws that say an employer can't pay everything. There are percentages that are available for garnishment, but you get the point. Those actions are ways in which a creditor, they file a lawsuit, they get a judgment, and then they take that judgment and they register it, and they're able to have a lien against certain assets that you own, and you can even send those in the form of a garnishment to people who owe you money. So how does a trustee protect when you have $100,000 that's sitting in an account that may have become $150,000, depending on what the investments were? How do you protect then that money from the claims of a creditor against a beneficiary? Because you may say, well, gee, that money is supposed to go to that beneficiary. Well, through a trust, through properly wording, you can create a spendthrift provision. And courts universally have said, in virtually all the states, have said that if you have that provision, then those funds are not subject to a garnishment or lien. The only thing they can do is technically, if they were to pay that money to a beneficiary and it were go into a bank account in the name of the beneficiary, at that point they could take it. Well, for one thing, you've done a whole lot of good by not simply taking the $100,000 and handing it out.
Right.
Remember, we've already fixed that. But you may say, well, yeah, but what about the $2,000 you might pay out a month? Well, it's true. If the $2,000 goes in the account, they could get that, but you can prevent that. I mean, you can pay the money directly to the beneficiary. There's so many ways to assure. And what you've really done is you've allowed the beneficiary to continue their life, to pay their rent, to pay their car payment. Things that need to be paid, you can protect all that. But it's still, you may say, well, but if they get the money and they let it accumulate in a bank account, once it's in their name, it's not in the trust name, it's in their name. And yeah, but that's the whole idea, is you can prevent that, number one. But number two is it's better to lose $2,000 in going into an account than to lose $100,000.
So, but this money would be paid to this heir, the beneficiary, in the form of a check. If
it goes into a check, the beneficiary can cash it and take cash, and it's protected. I mean, there's no way to take it.
Put it in a shoebox if they want.
Yeah. I mean,
it's not a good idea, but...
For you to make your point, that's correct.
Okay.
Yes, you could. So but here's the important thing, is that so much mischief, so many bad things can happen when you take a pot of money and hand it out to your loved ones. And I don't care if they're mature. I don't care if they have good judgment. I don't care if they're doctors, lawyers, whatever they are. When you put it in their name, they are vulnerable in a lot of ways, and there's nothing they can do about it. They can't go out and create a trust for themselves that has the power of what a third party can do, for obvious reasons. We can't go out and build a wall around our money and let us use it the way a third party can build a wall around their money and hand it to us. It's considered fair play, for lack of a better way to put it. It doesn't seem fair. So there are a lot of restrictions on your ability to create that sort of protection for yourself once you've received money, for you to be able to create a trust that will do all those things as effectively. Whereas when someone else gives you a gift and they put conditions on it that way, then it's not unfair to a creditor. It's not unfair to anyone else because, the debtor is not the one who created this. A third party did. You did. You created it. So these are examples that we've given here of the ways in which there's so much more yield, so much more good that you're able to provide those you care about than if you simply, through a piecemeal approach, through a box of designations, TODs, PODs, called non-probate transfers. I mean, I think of that, to be honest with you, as a mess, and it's just a bad idea. It does not resemble a plan, even if it dumps money directly into the hands of those you care about when you pass away. That is not a plan. Let me make another point, too. You should know that these monies under a non-probate transfer, they're still vulnerable to claims of creditors. So if you think that if you do a non-probate transfer that somehow avoids that risk, it doesn't. If first creditors under the law in Missouri, and this is the law in most states, they have to first make an effort to satisfy all their claims through the probate estate. And if they can't satisfy all their claims through the probate estate, then they can go to what's called a non-probate transfers. So it's different. But you should know that still there is an obligation of a creditor to make every effort they can to get the money they're owed through the probate estate. But when it's insufficient, they're allowed to seek out that payment through what we've defined for you, a non-probate transfer. And all those are vulnerable, including, incidentally, a living trust that was revocable at the time. Here's the test. The test was the settlor, or the decedent, was the decedent able to access that money to pay creditors at the time of their death? Could they have personally accessed that money? And if they had that reasonable degree of access, and another way of measuring it is, do creditors have access before the death? And if the answer is yes, then they have access after the death if the probate estate is insufficient. So there is still a barrier there. Now, that can be penetrated, but still there's a barrier first that has to be overcome, and that's the fact that there's money in the probate estate. Take that first, and once that's exhausted, then they can go for those other things. But a trust, if it is written correctly, will not meet that criteria at the time of your death. But that's another show. But still, if it were simply a revocable living trust, then it would be subject to the same vulnerability as to creditors at the time of your death. But now that's different. Don't confuse that with the conversation we're talking about when we're talking about yield. We're talking about yield meaning increasing the benefit to those you love with the money. Yeah, with the money that you leave them, so that they're protected as much as they can be from taxes and creditors and divorce and this litigious lawsuit society we live in. You can give them money that is special money. It has a special protection that makes it far more valuable than simply the face value of the money. I mean, how do you compare $500,000, for example, denuded of all these protections, to $500,000 with these protections? Is it worth more than $500,000? Yeah. We could argue about how much more, but surely we can agree it's worth more. Well, I wonder what it cost you in estate planning to create that. Did it cost you a couple $1,000 maybe? And you get the protections I just described? I mean, it's such an incredible deal. And it sounds like an argument by a lawyer on behalf of lawyers, but I can say this to you. I've made the same argument to family members who couldn't even come to me because they're in other states. But I would say this to you, even if you're going to another lawyer, if you're not going to TuckerAllen, I would still say to you, it's simply a fact. It's an incredible, incredible deal to be able to spend, and I said a couple thousand, maybe it's a little more. But the point is, to be able to spend that much money and get the value of what we've been talking about on this show.
And protecting your loved ones and yourself, of course.
Yeah, I mean, it's just not even, there's just no way to justify not doing it. That's all I can say. It's a stewardship function. It's a responsibility that we all have to those we love and care about. But anyway, I'm off my soapbox at this point. So
you love that soapbox.
Yeah, I do. I do love that soapbox. Okay, I guess this is a good place to stop. One thing we should mention is I think coming up on our next show, we're going to have Nina on, who attorney with TuckerAllen. She's going to be talking about how to protect your pets. Our
four-legged friends.
Yes, in your estate planning.
I've got a lot of questions about that.
Okay, this ought to be very interesting. Many of you know I'm a dog lover. As a matter of fact, Scout just walked in here. I don't think you could tell, but she came here a few minutes ago and I got distracted.
She barged in through the door. She was going to make her appearance.
Yes. Soon we're going to have to put her in one of these chairs. But
yeah.
In any case, so you'll find Nina's discussion, though, about how to do planning for the care of pets very interesting. And we have relatively new laws now that make that very, very feasible. So this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.